Okay, Mr. Germer, you're ready on Mr. Beck.
Yes.
People versus. First, we have Aaron Beck, case number 2352. Like Mr. Beck present here in the courtroom today. In second sentencing, if I could have counsel put your.
Sierra Coke on behalf of the people.
Thank you.
And just to make sure we have the right person here, Aaron, is that correct?
Yes, sir.
All right, Mr. Beck, did you have a chance to go through the pre-sentence report and talk to Mr. Germer about that?
Yes, Your Honor.
And Mr. Germer, do you have any additions, deletions, or corrections?
No, Judge.
And this is a one-year misdemeanor, so there are no supporting guidelines. Ms. Cope, do people have any additions, deletions, or corrections?
No, Your Honor.
Will have any allocation today?
I think this is appropriate. This entire circumstance was unfortunate, and I hope that Mr. Beck, he has no criminal history at all. He has no juvenile record, no misdemeanors, no felonies. I don't know why they acted this way towards law enforcement. They were just doing their jobs. I kind of wanted to ask for them to be forced to do a ride-along so they understand what law enforcement has to go through and how people acting like this just makes it much more difficult. But given that he has no criminal history, I think that Mr. Beck probably learned his lesson, and I think the recommendation is appropriate.
I do not agree the recommendation is appropriate as well. Mr. Beck, out of the four individuals that he was least culpable, Mr. Beck was not drinking. Mr. Beck was the only adult who was able to be drinking, or at least of age. But when the outside commotion ensued, he just went into the home, and at that point just wanted to stay away, and then did not let the officers in because the others just ran away. And I think that's what brought him into this situation. I would explain please to Mr. Beck that sometimes that situation, dealing with the officers and letting them in, or at least in the initial situation we were getting in, that would have been okay for him to at least comply with those orders. But again, Mr. Beck was of the mindset, at least, and not knowing how these rules work, that he was in the house, he was away from what his brother was doing, what the other two younger juvenile cousins of his were doing. I don't know if they were his cousins or his friends, but what they were doing, and they're the ones that ran off. And he said, I stayed there, they were there. I didn't do anything that was more culpable than what the others did, so I thought I was okay just complying with staying inside the house. And clearly there's factual disputes regarding that with Mr. Beck. But at least realize that there is some sort of culpability, that's why he accepted that plea. I think he understands that what caused them to be here before the court. So for those reasons, I think the recommendation is appropriate. I think Mr. Beck won't be before the court again and comply with terms and conditions.
Zach, anything you wanted to say?
No, yeah.
All right, I read through the report. It's an absolutely ridiculous situation. The act way that we did towards law enforcement, they were there for a legitimate reason. They were investigating the noise complaint. The proper thing to do is cooperate with the investigation into the noise complaint. I have no idea, other than just complete lack of disrespect, not even for authority, but just for that was displayed here, and I have no idea why any of you thought that was justified or appropriate. I can promise you, I thought about giving you some jail time, and the other Mr. Beck as well, just to you guys a little bit of a lesson of respect generally for other people. Prosecutor's not asking for it, so I'm not going to oppose it, but I promise you, if you're ever back before me again and you're found guilty of something like this, you will do some jail time. It will be clear to me at that point that you haven't learned your lesson. Do you think police shouldn't be on your property? If you think they need a search warrant, the right way to handle that is to comply and then challenge it later in court. That's the way the system's set up to work. You're not a lawyer. You don't really know what's allowable and what's not allowable. And so you're not in any position to tell them what they can or can't do at that point. your legal remedy, again, if they've behaved in a way that they weren't authorized to, if they've entered onto property that they weren't authorized to, if they've entered into a dwelling that they weren't authorized to, your way to challenge that is later through the legal process, not mouthing off, not acting like you know more about the law than the police do at the moment. Right. All of that being said, I think the court is going to accept the recommendation. The court will order that he serve 1 day in Crawford County Jail, credit for 1 day served, a crime victim's assessment of $130, court costs of $325, a fine of $300, attorney fees of $350, state costs. While this isn't jail time, this is going to be a substantial financial burden. So hopefully that will serve as appropriate punishment. Motivation for you now to take forward. There are no written appellate rights because this is a misdemeanor. So you have the right to seek an appeal of the sentence if you wanted to, though. If you wanted to do that, you would need to file the appropriate paperwork within the next 21 days. If you have further questions about that process. Otherwise, after the hearing, you just need to go over to the clerk's office.
As you anticipate half today and then perhaps the other half in the next few months.
Yeah, just work that out with the clerk's office. So, spoken anything further on this file?
No.
Mr. River.
No, sir.
Thank you, Mr. Beck.
Thank you.
All right, we'll take a brief recess until 9:30. Grigsby's case.
Yes, thank you.
We're on the record now in People versus Brian Grigsby, case number 235221. The record should reflect Mr. Grigsby's present here in the courtroom today.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, back, Brian Griggsby.
And Mr. Thompson, just so you're aware, I did receive a reference letter on behalf of Mr. Grigsby. I had a chance to read that reference today. Mr. Grigsby has had a chance to go through the pre-sentence report. About that.
Yes, Your Honor.
Thompson, are there any corrections? Suppose people have any corrections to the report.
No corrections.
Do the people have any objections that wish to address the court?
She has asked that her advocate speak on her behalf.
Mr. Griggsby, if you could have a seat. Let's move forward, please. You need to say your name correct.
Yeah,
Where are you speaking on behalf of today?
Miss Kayla Cummings.
Okay, thank you. Please say it, please.
Kayla has prepared an impact statement she wishes that I read, Your Honor. During the time that the case has bothered me, I have been more than anxious and depressed. I have sought counseling and therapy to better myself after the defendant's wrongdoing. In December, I found myself not working due to extreme mood changes and pressure I received after making my report. Some days in the guard were difficult as the defendant had a slew of supporters. In conclusion, I had a difficult time adjusting after my trust was betrayed by someone who was responsible for leading me. That's all you're on.
Ms. Coke, anything that you want to say? Yeah.
This was a really difficult case. It's very rare that we take a CSC case down to an assault and battery. And we talked about how difficult this trial would be on the victim and, you know, the possible way a jury can decide. The court sits in front of lots of juries. So we talked about this case could go either way. And Mr. Thompson and I spoke about that. I don't know how many times, but dozens of times we talked about this case and how hard this case was on both sides. Kayla is very, very nice. She's got a great future ahead of her. I hope that she can put this behind her. I think that Mr. Griggsby should have to do probation and counseling. That wasn't recommended, but I think that should be part of it. And I think that he should do the jail time that's recommended. I think that's appropriate, and I'd ask the court to order that. Thank you.
Mr. Thompson, if you want
Your Honor, this is a difficult case. This is a.
Can you guys come to the podium?
Yes, Mr. Andrew, if you can just go back and look. All right, thank you, Your Honor. This has been a very difficult case since the beginning, as you know, he said, she said, cases that happen in private are by nature, they're difficult cases. This is particularly difficult. We have a gentleman with no criminal record, almost 20 years in the guard. Very credible individual. He interviews very well, speaks very well. I had a lot of confidence that he had a very good chance at trial. I think he objectively had a very good chance at trial when you look at how the evidence shaped out. We got an offer for a misdemeanor, and we're just asking that Mr. Griggsby be sentenced for that misdemeanor, Your Honor. He did admit to the fourth degree. He would have defended that vigorously. Obviously, the court can understand when you get a misdemeanor plea offer when you're facing fourth degree CSC, 25-year sex offender registry, felony status. You can understand that, you know, he took that misdemeanor plea. He's here to take responsibility at that level. He's here to accept this court's conclusion, this court's judgment of sentence, Your Honor. We're just asking that he be sentenced according to what he pled to, Your Honor. And it is a misdemeanor. I think the court can take notice. The prosecutor's office doesn't often take felonies down to misdemeanors, doesn't often take CSCs down to misdemeanors. I think that reflects the strength of the defendant's case here. I think that reflects the defendant's good background and good character. And I think it reflects some proof problems here. And I think that's why it's entitled sentence for a misdemeanor. I think it's within the court's discretion, within that 93-day misdemeanor. I don't know, the probation and counseling, if there's anything inappropriate about that. I'll tell you, Mr. Griggsby is facing some collateral consequences here. He's at risk of separation from the Army. He's going to vigorously defend that because I don't think that would be appropriate for a misdemeanor charge, but he is going to vigorously defend that. He does accept responsibility here. He accepts, he took the plea, takes responsibility for that misdemeanor assault and battery, Your Honor. He apologizes to the court. He apologizes. His judgment was not good that day. He thought this was a consensual encounter, but he understands that he has to take responsibility, that he was in a position of some authority here, and that he needs to reflect on his actions and needs to do better in the future. So he does accept all that, Your Honor, but I do just want to make the point that this was pled down to misdemeanor for a reason, and just ask the court to consider that. I know it's a difficult case for the court. You got competing versions before you, but that is our request here, Your Honor. We have a very strong letter of reference for Mr. Griggsby. He's got almost 20 years in the guard, no record before this. Just ask the court to take all that into consideration.
Mr. Griggsby, anything you wanted to say?
Yes, Your Honor. Your Honor, I want to say that I made some bad decisions. I want to say that I feel as though over the past year and a half, because of this, I have wasted my time and your time. And I'm already at risk of losing everything, even with it being pled down to a misdemeanor. They're trying to put me out of the military. And I don't have almost 20, I actually have 27 years in the military. 27 years, I've never been in any trouble. I don't have any criminal record. I have a family, I have a mother that has dementia that I'm the guardian over. I'm sorry for the whole situation. And I just want to say whatever you decide is the outcome that I have to do.
All right, thank you. I did read through the report, so I'm familiar with the circumstances as they're reflected in the report. I don't have a lot of information, you all have police reports and interviews and everything else. I don't get any of that. So I go by what's in this report, and I go by the plea in this case. And you pled guilty to assault and battery. The only real difference in my view in this case between that and the fourth degree is was the unwanted touching for a sexual purpose, or was it just a consent to touching? And that's correct, but to the assault and battery. So in terms of what the court can consider you guilty of, it kind of takes the sexual part out of this, but you have admitted guilt to improperly touching this individual. And I don't think you can, I don't think it's fair for the court to somehow act like something improper didn't happen between the two of you, because I think clearly it did. And based on the information I have, I think it did. And I think what's really unfortunate about this circumstance, and it's this way in a lot of circumstances, is people start moving into camps. They're either in your camp or they're in the complaining witnesses camp. And it really puts, I think, a lot of unfair pressure on her when she's just reporting what happened. And what she reported is something in terms of the unwanted touching that you pled guilty to. So, I don't think it's fair for people to put pressure on her, act like this didn't happen. And ma'am, I hope that you don't feel that way, and I hope that you're able to get help and that you can accept that because this individual did plead guilty to improperly touching you and improper contact. And I think it's important that you know that, understand that, help you going forward. And Mr. Griggsby, regardless of what your view of the circumstances, you've admitted guilt for that, you accept that as well. In terms of what an appropriate sentence is, I do think the plea acknowledges and recognizes some of the mitigating circumstances that you mentioned. We don't have a criminal history. I have no doubt that there's going to be some collateral consequences to this that are going to be very detrimental to you going forward. I think it's really unfortunate that after you built up such a long history with the military that you're in danger of losing all of that because of some bad decisions that you dictated. In terms of the appropriate sentence in this case, I think the recommendation is appropriate. I think a short term jail is an adequate sanction so that you understand that what you did was wrongful and that there's a consequence to that. I think the misdemeanor plea recognizes the mitigating factors here. And again, I said what Mr. Thompson and what Ms. Coker said in terms of why that plea was offered in this case. So the court is going to sentence you to 30 days in the Crawford County Jail. You have credit for 1 day served. The court is going to order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, $50 state costs. You do have the ability to seek an appeal of this sentence. If you wanted to appeal the sentence, you would provide. More questions about that, Mr. Thompson? Questions for you? Spoke anything further to address?
No, thank you.
Nothing further. Thank you, Mr. Griggsby. We're going to have you go with the courthouse this time. You can get, or I'm sorry, Mr. Thompson. All right, People versus Beck, case number 235266.
You're welcome, yeah.
Right up to the podium. Records, so there's no mix-ups. You're Austin Beck, is that correct?
Yes, sir.
Mr. Beck, you had a chance to go through the pre-sentence report and talk to Mr. Ritter about that. Or I'm sorry, Mr. Thompson.
I believe so.
Go ahead and take your hands out of your pockets and step in the courthouse room.
More time to talk to Mr. Thompson about the pre-sentence report.
Yes, sir.
We have Miss Melon here, Mr. Thompson.
She's lodged.
She's out.
She's around.
We'll take a short recess. We'll come back in about 10 minutes.
All right, please.
Right, back on the record, and People versus Beck. Mr. Beck, you now had an opportunity to speak with Mr. Thompson.
Yes, sir.
Mr. Thompson, are there any additions, deletions, or corrections to the report?
No, Your Honor, thank you.
Ms. Coe, do people have any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for allocation?
And I think that Mr. Beck is in a different position than his brother. He's 20 years old. He already has 4 misdemeanors and a juvenile record. The court can look over his criminal record and see it's not going well for Mr. Beck. And if he continues on this path, he's probably going to start going to jail and then prison. He has a chance to make some changes to his life and not go down that road. I have no idea why he took off. I mean, the police don't want to be in a position where they're responding to noise complaints. That's not their job. But or it is their job, but when they get there, that's not what they need to be doing, is chasing around 20-year-olds who are acting rude. And his behavior just made this so much more difficult than his brother. I do think a short jail sentence is appropriate, and by short, I mean 7 to 10 days. I hope that he learns his lesson from this. I hope he turns his life around, and I hope that we don't see him again. Thank you.
Thank you, Your Honor. I understand the prosecutor's comments. I take a different view on this. Mr. Beck is very young. His brain is not fully developed. Under the influence of alcohol, the police came by and he ran away. Of course, familiar with the phenomena. I'll leave it here. That's ever happened. Mr. Beck got apprehended. He's fixing some fines here. Court had to weigh a lot of the same considerations with his brother, ultimately arrived at fines and costs. I think that's fundamentally in line with how I would ask the court to approach this. Mr. Beck was drinking alcohol underage, ran away from the police. I don't know what difference 7 or 10 days in jail would make in this circumstance. If Mr. Beck wants to make a course correction, if he wants to take any lessons from this, he will. If he doesn't, I don't believe 7 or 10 days in jail is going to change that. I believe fundamentally that he got caught, he admitted what he did, and fines and costs is an appropriate consideration. I think when you're younger like Mr. Beck, you have, the kind of earning power he does at 20 years old. I think the fine is pretty significant. Yeah, $1,000, $1,100. And I just asked the court to consider all that. Thank you.
Mr. Beck, anything you wanted to say today?
No, sir.
All right, familiar with the facts of what happened in this case and your involvement. Mr. Beck, in a completely inappropriate way to deal with police for beginning. And I told your brother this, I think, the police show up, they're there investigating a noise complaint, they're there for a valid reason, and your role at that point should be to cooperate with the investigation, not to give them a hard time, not to call them names. If you think they don't have the right to enter onto the property, if you think they don't have the right to enter into the home, your option is to challenge that later in court. It's not up to you at that point to tell the police what they can or can't do. You really don't know. You've got a high school education. You don't really know anything about the law, when it applies, when it doesn't apply. Have a good argument for the police not doing what they're doing. And it's time to make that argument later, or through a lawyer, somebody who knows what they're talking about, not about police at the time. Not to mention, it just shows a general lack of respect for adults, for people in authority positions. Not to mention, already doing something illegal by drinking underage. Not to mention, you've already been in trouble a couple of times and been given an opportunity through HIDA, which to your credit you successfully completed, but which should have taught you something about how to handle yourself in these kind of situations, not get yourself into deeper trouble. Is exactly what you did in this case. I think your case is different than your brother's. It calls for a different punishment because of your, number one, your involvement in running away. back, and you've already been through this a couple of times, been on probation, haven't really learned your lesson. So the more times you do that, the less it looks to me like somebody who's just making a bad decision because of you, and somebody who just doesn't care and do what they want to do when they want to do it, worries about the consequences later. So in this case, I do think a short jail stay is appropriate to provide a degree of punishment for you. Hopefully to impress upon you, again, the importance of when you encounter the police, to cooperate with the police, to challenge what they're doing later. You think you have a legal argument to do it. So the court is going to sentence you to 14 days in Crawford County Jail. You have credit for 1 day served. The court is going to order that you pay a crime victim's assessment of $130, court costs of $325, a fine of $300, attorney fees of $350, $50 state cost. You have the ability to appeal this sentence. If you wanted to appeal it, you would have to do it within the next 21 days. If you have any questions about that, you can ask Mr. Thompson. We'd be happy to help you with that. Ms. Koch, anything further that we need to address up correct?
No, thank you, Your Honor.
Nothing further, Your Honor. We go with this gentleman right here.
Case number 225217.
Sierra Coke on behalf of the people.
Thank you, Your Honor. Jason Thompson, on behalf of the defendant, Jamie Melon, Your Honor. We have two matters to address today. I believe Miss Melon was picked up on a bench warrant for non-appearance, and her bond was revoked by the court. I believe she did want to address her bond status. But we also we're conducting this as a status conference, and there is a plea offer in this matter. I believe Miss Melon wishes to take advantage of it, Your Honor. Plea offer in this case would be the original charge is resistance of obstructing arrest. It's a 2-year felony. There's an offer to have Miss Melon plead to an attempt, which would be a 1-year misdemeanor / attempted felony.
And Ms. Melon,
She's been in for about a month. I believe it's about a month, Your Honor. She got picked up in February.
She was lodged on 2/12.
oh, got it. All right, thank you. Ms. Koch, is that a correct statement?
It is, yes.
Ms. Melon, is that how you wanted to proceed today?
Yeah.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Ms. Melon, are you currently on any kind of probation or parole?
I'm on probation.
I believe she's on probation out of Otsego County, Your Honor.
Felony probation?
I don't believe it's felony probation.
Do you know if your probation officer there or your plea here today?
She was contacted.
I don't believe so. My office made contact with Otsego County. We're concerned there may be a bench warrant for Miss Melon. So we advise that she's around 5, but Miss Melon is not a probation officer about the potential danger.
So Ms. Melon, you understand that by pleading guilty here today, that could result in a violation of your probation there in Otsego, and then you could face some additional penalties for violating your probation.
Yeah, I do.
You understand that?
Yeah, I do.
Okay. And then, as Mr. Thompson said, the maximum penalty you could face on this charge would be up to 1 year. You understand that?
Yeah, I do.
With those two things in mind, how do you want to plead today to this charge?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you. And the right to testify to trial yourself if you want it. Do you understand all those rights?
Yes, I do.
You understand that you're giving up and waiving all of those rights by pleading guilty?
Yes.
Has anyone threatened you with anything to get you to guilty because you are guilty.
Yes,
It happened on March 4th of 2023, is that correct? About a year ago?
yes,
Okay. And on that day, were you here in Crawford County?
yes, I was.
And did you come into contact with a Crawford County deputy?
Yes, Officer Taylor, yes.
Was he wearing his police uniform at the time?
Yes, you.
Were you aware that he was performing his duties as a police officer?
Yeah.
What did you do to resist or to try to resist?
Well, I ended up hiding in the trailer, and he did ask me to get out, and I ended up getting out, but I ended up getting caught fast stuff.
Okay.
So I ended up, like, I don't
Were you hiding to try to avoid the police?
well, I hid in the trailer. Not that I was, like, I guess I just hid in the trailer or not,
You hid because you didn't.
but I
want-
hid, yeah.
You didn't want to have to encounter the police. So very satisfied with the fact.
Yes, Your Honor.
Yes. Ms. Coker, are the people aware of any threats, promises, or inducements other than what have been placed on the record?
No, Your Honor.
Mr. Thompson?
No other promises or conditions.
Ms. Coker, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Thompson?
Yes, Your Honor.
Ms. Melon, the court finds that your plea is knowing, voluntary, and accurate. Court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. So, your position on the request to, are you just asking if I'm reinstated?
We are here.
Your Honor, she had a failure to appear in this case early in the case. Then, of course, we had the set for jury trial and she failed to appear as well. It took us a little while to locate her. And then in her last case that she had here in Crawford County was a possession of meth case last year. And she entered her sentence, or she entered her plea and then didn't appear for sentencing. So I'm not real confident that she's going to appear for sentencing.
All right, I do have concerns, Ms. Melon, about your appearance going forward. You failed to appear on January 16th, and you failed to appear. So I think and in light of the plea here, we're no longer in a pre-trial posture in this case. So for all those reasons, the court finds it the sentencing. In addition, there may have, Mr. Thompson indicated you may have some warrants out of Seagull that you need to take care of. For all those reasons, I think it's appropriate to have the custody.
I would just ask them to conduct sentencing.
We will, and because this is a misdemeanor, I just need a misdemeanor. I'm trying to cost any recommendation for jail. So.
Yeah, I think she's got a PSI from about a year ago, so.
Well, there's a misdemeanor PSI that still needs to be done.
Yeah, but hopefully some of the biographical background is already.
So, we'll set it as soon as we're sure to get that taken care of.
Thank you, Your Honor.
30 days.
Yes, you're on.
Mr. Burns here, Your Honor.
Okay,
Mrs. Burns.
Okay, Mr. Burns, would you like to come up?
Your order on the two animal crocodiles.
So this case is just you?
Yes, sir.
So I'm gonna have you-
All right, yes.
All right, Ms. Simmons, are you able to hear me okay?
I am. Thank you, Your Honor.
And Mr. Backman?
I can hear you, Your Honor, and I can hear Miss Simmons as well. Can you hear us okay?
Yep. Good. And then we have Mr. Burns. He's present here in the courtroom, seated at the council table. Hopefully you can see him on camera there. We're on the record now in Burns versus Nish. This is case number 2311430. We have both counsel present, as I already indicated, by video. Mr. Burns, or I'm sorry, Mr. Nish by video, and Mr. Burns here in person. This is set for a hearing today. Ms. Simmons, how did you want to proceed?
There's going to be a plea, and I'll let Mr. Backlund kind of put that on the record a little bit so that he can guide the court through what we're going to be doing.
Thank you, Mr. Backlund.
Certainly. I've had a chance to speak with Mr. Nish and also Ms. Simmons in regard to this matter and how we would like to proceed. And Mr. Nish is going to enter a plea of no contest. Based on my discussions with Ms. Simmons, the recommendation would be any sentence or penalty would be suspended pending any further complaints related to violations of the PPO. And if there are no further incidents or complaints for violations of the personal protection order during its term, the complaint would be dismissed, and so would any pending penalty for Mr. Nish. So for example, a suspended sentence would be removed upon expiration of the PPO if there are no further complaints or incidents.
All right, Ms. Simmons, is that correct?
That is correct, Your Honor, and I've explained that to Mr. Burns also, and I think we're ready to proceed accordingly.
And Mr. Backlund, what is the court going to use as the factual basis?
There is no police report in this matter, Your Honor. So if we could take testimony from my client, if the court would be satisfied for a factual basis presented there.
Or the petition. We were also talking, Judge, if I may, I apologize to interrupt. The request for the PPO violation, I believe there might be some documentation presented by Mr. Burns. That would also be acceptable if Mr. Backlund agrees with that for you to review for the basis for the no contest plea.
Well, and I did review that prior to the previous hearing, and I'm willing to accept that if counsel agrees for the court to accept that as the factual basis.
That's acceptable with us, Your Honor. Absolutely.
And
All
people
right.
do not object to that either, Your Honor.
Okay, and it's made part of the court file because it was filed by Mr. Burns as part of this proceeding. All right, so Mr. Nish, can you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, I do, Your Honor.
Thank you. You can lower your hand. Mr. Burns, you understand that, or I'm sorry, Mr. Nish, you do understand that you have the right to have a hearing as to whether or not you violated the PPO in this case?
Yes.
You understand that by pleading no contest that you're going to be giving up that right?
Yes.
And you understand that by pleading no contest, that the maximum possible penalty you could face for violating the PPO in this case would be up to 93 days in jail and or a $1,000 fine?
Yes.
With all of those things in mind, what is your plea to the violation today?
Not guilty.
No contest.
No contest, I mean.
All
Sorry.
right. Has anybody threatened you with anything to get you to plead no contest?
No. No, sir.
Has anyone promised you anything other than what we've said here on the record today?
No, sir.
Is it your own free choice to enter this plea?
Yes, it is.
All right. So in reviewing the file, number one, the court finds that there was a valid personal protection order in place signed by this court on or about July 13th of 2023, and that the expiration of that personal protection order was July 13th, 2024. So at all times pertinent to this matter, there was a valid personal protection order in place that prevented contact between or by Mr. Nish as to Mr. Burns including stalking, following, or appearing within the sight of Mr. Burns, appearing at his workplace or residence, approaching or confronting him in a public place or on private property, entering into or remaining on property owned, leased, or occupied by Mr. Burns, and various other ways of contact. Looking at the filing and the show cause that was filed by Mr. Burns regarding the violation, the court finds that there is an adequate factual basis to support a finding that Mr. Nish did violate the personal protection order as alleged. Mr. Backlund, have you reviewed that filing by Mr. Burns?
I have, Your Honor, yes.
Do you agree that it would provide a factual basis?
Yes.
And Ms. Simmons, have you reviewed it as well?
I have, and I do think it supports a factual basis, Your Honor. Thank you.
All right, thank you. So Mr. Nish, the court finds that your plea is knowing and voluntary. The court is satisfied based on the show cause filing that there is a factual basis to support a finding that you did violate the personal protection order. In this case, the court will accept your no contest plea. Mr. Backlund, I guess what I'd like to do in terms of the sentencing is, I know we've placed that agreement on the record. If you can submit something in writing with Ms. Simmons' stipulation as to the terms going forward based on the no contest plea, so that it's in the file and so that all parties have a copy of that, so everybody knows where they're at with this going forward. Can you prepare that and submit that to the court for signing?
Certainly, Your Honor.
Okay, Ms. Simmons, do you have any objection to that process?
No, but I would ask that, would that require Mr. Nish to return for sentencing, or will it just be incorporated as the sentence, or how does the court want to handle that?
That would be incorporated as the sentence in this case, and there would be no further hearings unless there's issues going forward.
Okay, thank you, Judge.
Okay. All right, Mr. Backlund, anything further today?
No, Your Honor, thank you.
Yeah, we got it.
Ms. Simmons, did you have anything further for the record today?
Nothing further. Thank you very much, Your Honor.
Mr. Burns, do you have any questions?
No, sir.
Okay, thank you, that's all for today.
All set then, Judge? Thank you.
Yes, I'm sorry, all parties are free to disconnect.
Thank you.
So, 1 second.
It's not probably out on the phone, but I need to know Mr. Scarboro. That's the thing.
Okay, are you ready on Mr. McCasker? People versus Chad McCasker, case number 235275.
Jericho, on behalf of the people.
Good morning, I'm Spencer Clayton, training on behalf of Oscar is approaching, standing to my right, number 77302. Your Honor, I am standing for the attorney record in this case, Mr. Maurice Davis. We do work in the same office. Sir, is it with your permission that I stand in for Mr. Davis?
Yes, sir.
Thank you. Can you state your name for the record?
Chad Brian Oscar.
You know, if you grab Mr. Mascar's consent. We're waiting for that, Mr. Mascar, if you had a chance to go through the pre-sentence report with counsel.
Yes, sir.
Counsel, I did receive a couple letters on behalf of Mr. McCasker that I had a chance to review prior to today's hearing on the PSI. Are there any additions, deletions, or corrections?
One correction, Judge, she is married, not divorced. It's reflected on page 1. I think also in the report as well, but like that, correct. Wait, that's here present as well.
All right, the court will order that the PSI be amended to reflect that Mr. McCasker is married. Any other corrections?
No,
Ms. Koch, do the people have any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, it's hard to figure out what Mr. Mascar, who's 31, has no juvenile history, no misdemeanors, no felonies, no criminal interaction with the criminal justice system at all, was thinking when he decided to take off and engage in a dangerous 80-mile-an-hour high-speed chase. Him and his friends were all in danger. He ended up rolling his ORV. He could have been very, very hurt. Other people could have been very hurt. The officers could have been very hurt. This could have turned out much, much worse for Mr. Mascar. His attorney advocated strongly. We gave him an attempt flee and elude, which will keep him from having a felony on his record. Frankly, I think this is probably a flee and elude third based on the fact where they were going. But we did do this plea offer based on his lack of criminal history. I think punishment is appropriate. There was no probation recommended. I spoke to the PSI person that prepared it, and they indicated that they don't think he will commit these crimes again, but that punishment is necessary. So we'd ask the court to follow the recommendation. Thank you.
Thank you. Counsel, any allocation on behalf of your client?
yes, just briefly, Judge, I would agree with the people in the sense that it is hard to tell what he was thinking. He doesn't have any criminal history. Not felony, not misdemeanor. He has a good job. He's a family man. He has a newborn daughter. This has already cost him a tremendous amount. The SUV, the ORV was forfeited and it had an approximate value of $25,000. He told me he's going to have to make payments on that for the next 5 years. There's the potential that he could lose his job. He's lost his license. His wife has to take him to work. That's 50 miles one way. He's indicated to me that they're looking to move closer. So that's not such an issue, but at the same time, with the housing market where it is right now, it's kind of economically not possible for him. So as a result of this, it has cost him a tremendous amount of money. It will cost him and his family already a hardship. And rightfully so. This was a terrible decision, and one I think that's reflective in the report that he's owning. And he knows this was completely stupid. I don't think, as the prosecutor stated, this is ever going to be something that repeats itself. I think the penalty obviously is warranted, but I'd ask the court to consider the fact that it's going to already cost, and it already is costing them a tremendous amount. I know that there's a statement you need to read as well, Judge.
Mr. McOsker, anything you wanted to say?
Your Honor, I'm deeply sorry for what I have done. I'm so ashamed of myself. I did something that put others in danger and caused my family a lot of pain and grief. My daughter was born a week and a half after this. My wife was induced early due to preeclampsia. We were in the hospital for 5 days. I never left her side until we got home. I went out to our garage and cried uncontrollably. I was so mad at myself for letting them both down when they both needed me most. I felt like such a failure. I know I did wrong, and I know promises don't mean a lot in today's day and age, but to me they do. I promise to you, Your Honor, I will never do anything like this heinous again, and will always put my best foot forward for my family and society. I just ask for leniency so I may go home and be the best husband and father that I can be. I apologize.
And Your Honor, if I may add one more thing, he has about a week's vacation for where he works at a steel mill. He's a very good job. He's told me that he would be willing to report for weekends if the court would consider it. Certainly, I told him that would be within the court's discretion. That's all I'm actually granted.
All right, thank you. Mr. McOsker, I did read through the pre-sentence report of this case prior to today's hearing. Also, I did receive the letters that indicated that were submitted on your behalf. And yeah, I mean, I agree with both the attorneys here. It seems like something out of character for an individual at your age and with no prior criminal history. The question is, how do we address it going forward so that there's a degree of punishment for you for your bad decisions here, but also a recognition of the mitigating circumstances. And there's been a lot of changes in Michigan law recently with regard to jail time. Courts are encouraged and even required to look at options short of jail where appropriate, unless there's a specific reason to order jail time. I think an argument certainly could be made for it here, given your actions and the amount of danger that you put everybody in. People get hurt in these side-by-sides all the time. Killed. I just had a case in Calcasas where one rolled over, killed somebody, rolled right over their head. They're building something. So it can be dangerous when not operated correctly and certainly not under these circumstances. But I think an argument could be made for jail time. I think an argument could also be made that financial punishment, given your lack of prior history and given what I view as likelihood that you would not engage in this kind of activity again. Also be made. So looking at circumstances as a whole, I think it's appropriate to impose punishment in terms of financial obligation as opposed to jail time here. So the court is going to order, number one, that you pay a crime victim's assessment of $130 or cost of $325, state cost of $50, $500. The court's going to order that you serve 1 day in the Crawford County Jail with 1 day served. You have the ability to appeal the sentence. If you want to seek an appeal of this, you can file that within the next 21 days. I'm sure your counsel can help you do that. That's something that you want to pursue. Otherwise, after court today, go to the clerk's office next door and make sure that you pay off those fines and costs. Still anything further for the record?
No, thank you.
Counsel, any further?
Okay, thank you. I'll pay his fine today.
That's all for today.
Is that calling Mr. Scarborough's case?
Yeah.
I was just checking out, so he's not here.
We're on the record in People versus Scarboro, case number 235253. Council can put your appearance on.
Sierra Coke on behalf of the people.
Thank you, Rabbi Gurmati, and people, Mr. Scarborough.
Thank you. This hearing was set for 10:15 for sentencing, now 10:30.
No, Judge, I in fact was in the hallway, looking for Mr. Scarborough when the court called this case. Mr. Scarborough is not here. I had my office call at like 9:45 or so to just check Mr. Scarborough was going to be here in court. Because the last time he was stuck in a ditch and it was a snowy condition. The roads are fine today, so I wanted to make sure he was going to be here. The phone number we have has been disconnected.
Okay. All right, Ms. Polk, the court would request that your office prepare a bench warrant for Mr. Scarborough's arrest. Court will take that. Is has anything held in the Crawford County Jail without a bond until we can get a sentencing hearing scheduled again. Ms. Polk, any further?
No, thank you.
Judge, if Mr. Scarborough is apprehended and lodged with the court at that point, just going to sentencing at that point, or consider going to sentencing at that point, since he would be incarcerated.
Correct.
Okay.
Yeah, as soon as he's arrested, we'll set it for a sentencing hearing.
Okay, thank you, Judge.
The next hearing is set for 10:45. We'll be in recess until that. Okay, People versus David Yankee, case number 23527.
Sierra Code could be after people.
Sean Ward on behalf of the defense, Your Honor.
Set for sentencing in this matter. Mr. Yankee, if you had a chance to go through the brief. Mr. Warden, are there any additions, deletions, or corrections?
No changes to make, Your Honor.
Ms. Melon, do you have any additions, deletions, or corrections?
No, Your Honor.
Anything on behalf of the people?
And are similar to his co-defendant, I believe the recommendation is 30 days in jail with no incarceration. Mr. Yankee has no prior history at all with the criminal justice system, no felonies, no misdemeanors, no juvenile record. I do think that this behavior, having watched the body cams and dash cams several times, was probably a flee and elude third. I took into consideration all of the things with his criminal background when I offered him this misdemeanor. What they did was really, really dangerous. They were going through neighborhoods. One of them ended up in a resulted in a crash and an overturn. None of the officers were hurt, luckily, and neither were the defendants. But we are seeing more and more of these fleeing and eluding to the point where they're just putting people in danger for absolutely no reason. Mr. Yankee was the first one in his group that took off and started this flee and elude that ended up with multiple vehicles driving around the county at 80 miles an hour late at night. I think the recommendation is appropriate. I'd ask the court to follow it. Thank you.
Thank you, Mr. Warden.
To argue with those comments, Your Honor, I would ask the court consider no incarceration given the collateral consequences Mr. Yankee has already suffered. Forfeited his side by side, which is more than a $10,000 financial loss to him. And this is a person with a high school education who does well, but is an RV salesman. That's a significant consequence. He's also lost his license for a period of a year, which is also a significant collateral consequence for someone with no history. He's also probably the most contrite person I've ever met in the last 20 years of doing this. This is a person who's been beating himself up miserably every time we have to talk about this case. He knows what he did was inappropriate. He knows what he did was scary and dangerous and stupid, just stupid. Sometimes that's forgivable. And this is not something where he's not going to have some sort of consequences. Something that's going to live with him for a long period of time. And he'll be lucky to keep his job. He has to drive for work. And right now we're trying to figure out ways to get around that. And, you know, money comes and money goes. Maybe he'll have a side by side again. But the last conversation I had with him was he'll never, ever, ever even think about getting it because he feels so terrible. So I'd ask the court to consider fines and costs only. This is a person who's done more to himself than I think the court system could ever do. And this is a person who has had one entry into the criminal justice system. Thankfully, I probably will never see him ever again in my life. And that would make me very happy.
All right, thank you. Mr. Yankee, anything you wanted to say today?
Yeah, I wrote a letter for you. My name is David Yankee. I'm writing on behalf of myself. I'm a resident in LaGrange. I've been a law-abiding citizen my entire life. I've worked at Highland Ridge RV for 12 years. I'm currently an electrical group leader. Been holding that position for 11 years. Writing you today to ask for leniency in my sentence of this case. I understand that I made a mistake and I'm truly sorry for my actions. And I've learned a valuable lesson regarding this case. I'm not going to make this mistake again. I've never been in this kind of trouble with the law. And I'm asking for leniency so I can have the opportunity to support my family. I'm the only one in my household that supports my household. My son has autism also, and I'm very involved with his schooling and his care. I would really hate to see my children suffer for my actions. I need to also take responsibility for my actions, so I'm taking this very seriously. So if there's anything I've learned from this, I can't always hang out with my friends and do stupid things together. I need to focus on my actions and repercussions of my actions and be a better role model for my kids. Also, learn this is a big financial lesson as well. I do respect the decision you make in this matter. Thank you for your time.
All right, I thank you. I did read through the report. Obviously, I had Mr. McCasker was here in front of me earlier this morning, who was part of this incident. A lot of my comments that I made to him, I'm going to make to you as well. But I'm well familiar with the circumstances based on my actual cases here. And yeah, the lawyers are right. This is a really stupid thing to do. I can't understand why either of you made the decisions that you made. Again, I think he's younger than you, but you're both grown men who managed to get through a lot of your life without ever having any issues. And why on this particular night you decided that this was your time to be a rebel and to run for police, I don't know. But clearly a wrong decision. Put a lot of people in danger, including yourself. I told Mr. McCasker I had a case over Docket recently where somebody rolled a 4x side by side and rolled right over their head. They were killed instantly. That could easily happen in this case to one or more of you or to the police. And so I hope that you do take this as a learning experience and that you, next time you think about potential consequences before you engage in the action. The question here is how to deal with this now. I told Mr. McCasker, there's mitigating circumstances here based on his lack of criminal history if you're in the same position. So, the court has a lot of options available to it. One option is jail time that serves as a punishment. There's been some changes in the law in Michigan recently, which requires courts to look at options other than jail time to punish people where it's appropriate. I think an argument could be made that jail time is appropriate here based on your actions and the danger that you put people in at night. But again, there's also some mitigating factors here too, which allow the court to consider other options short of that. And I think in this case, the financial penalties are sufficient to impose upon you how important it is that you not engage in this activity going forward. Your previous lack of criminal history gives me some assurance that this was a one-time mistake you're not going to repeat, which also again plays into my decision not to impose jail time. So the court is going to sentence you to 1 day in the Crawford County Jail credit for 1 day served. Crime victims assessment of $130, court costs of $325, state cost of $50, and a fine of $500. You do have the ability to appeal the sentence. If you wanted to do that, you would have to do that within the next 21 days. If you have more questions about that, we went before you report today, you go to the clerk's office to make arrangements and pay those next costs. So is there anything further that we need to address today?
No, thank you.
No, thank you.
That's all for today. People versus Stampfly, case number 235220.
Sierra Coke on behalf of the people.
Your Honor, my name is Craig Elhart. I'm appearing today on behalf of Mr. Stampfly. He's first, my right.
Matter, we got the trial currently set for April. This is a final status conference, so today would be the final day to enter into any type of plea. Mr. Elhart, we can.
Oh, easy. You okay? I'm good. All right.
Are we going to be proceeding with trial? Do we have a plea agreement?
We have no plea agreement.
Oh, Ms. Coke, are the people prepared to report the trial as scheduled?
We are, Your Honor. There are some non-standard jury instructions because there isn't a standard one for this. I almost have them finished and we'll get them filed early, either tomorrow or Monday.
Is this a firm date, Your Honor? Is this a fact?
This is a firm date.
Judge, that is the only trial that day, 4/8.
So firm date will be ready to go. You guys are.
April 8th. April 8th. Is that what you said? Thank you. Thank you very much, Your Honor.
So Ms. Coke, I'll just ask you to submit those instructions. Elhart, you don't have to submit a full instruction. Once you'd like to request or any objection. Yeah.
I hate for her to do all the work.
What's that?
I hate for her to do all the work.
Well, you guys could get together
All right, thanks, John.
Okay, thank you. We'll see everybody on the morning of the 8th. One more thing, council. I'm just gonna request that you and your client are here by 8:30 and then you're both ready to go at 8:30.
That will be no problem at all, Your Honor.
Very good, thank you. People versus Daniel Rotan, case number 245286.
Here, Coke, on behalf of the people.
Dylan Jaskowski on behalf of Mr. Rotan, filling in for Mr. Krusch today.
Mr. Rotan, do you have any objections to Mr. Jaskowski appearing on your behalf today?
No, Your Honor.
We're set for a status conference in this case. It looks like it's Mr. Rotan's first appearance before circuit court. Mr. Jaskowski, if there have been any plea discussions.
Yes, Your Honor. We do have a plea discussion. He has agreed to enter up a no contest plea in this matter to an added count.
It is added count 2. It's school intentional threat. It's 750.235 B1, and the maximum fine is 1 year and or $1,000.
And Mr. Jaskowski, what's the reason for the no contest plea?
Civil liability regarding an ongoing employment dispute, Your Honor.
Okay. Ms. Pope, do we have a police report or something? Or do you have?
I do have a report.
And Ms. Pope, do people have any objections to the no contest plea?
No.
Just give me a moment. Report. Okay, Mr. Rotan, have you had an adequate opportunity to speak to the attorney about this plea agreement? Is that how you want to proceed? So, you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. Yes, Your Honor. Again, Mr. Rotan, are you currently on any kind of probation or parole?
I'm not.
And as Ms. Koch indicated, you understand that the maximum possible penalty that you could face for this charge would be up to 1 year in jail or a $1,000 fine. That maximum possible penalty in mind was that charge today.
No contest?
Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt if you are guilty. You have the right to have any witnesses against you if you're at trial and question those witnesses. You have the right to have the court order any witnesses on your behalf if you're at trial. You have the right to remain silent during a trial and do not have that silence used against you. You have the right to testify at a trial yourself if you want it. You understand all those rights. For sure. You understand that you're giving up and waiving all of those rights by pleading no contest. And won't threaten you with anything to get you to enter this plea. Has anyone promised you anything other than what was said here in court? Is it your own free choice to enter this plea? Mr. Jaskowski, have you reviewed what they're marked as Exhibit A?
Yes, Your Honor, I have.
Do you agree that the provided factual basis for finding it real?
Yes, Your Honor.
Ms. Pope?
Yes.
So the court's referring to Crawford County Sheriff's Department incident report number 233094. The court's going to mark that, or it's been marked as Exhibit A. The court's going to admit that. I reviewed it. The court finds that the information provided factual basis in this case Ms. Koch, are the people aware of any threats, promises, or inducements other than ones placed on the record?
No, Your Honor.
Mr. Jaskowski, are you?
No, Your Honor.
In this scope, are the people satisfied that the court has complied with statute or will undertake of this no contest?
Yes, Your Honor.
Mr. Jaskowski?
Yes, Your Honor.
Mr. Rotan, the court finds that your plea is knowing and voluntary. The court is satisfied that based on court exhibit A, there is a factual basis to support a finding you are guilty of this added count 2. The court will accept your no contest plea. We'll set this matter for a sentencing hearing. Will be notified of the date and time of that hearing. I'm going to request a misdemeanor PSI on this, so you're going to meet with Mr. David before you court room today. And then otherwise, just make sure that you stay in touch with your attorneys prior to the sentencing hearing. Okay.
Yes, sir. Thank you.
Your Honor.
Yes.
Now that the plea has been entered, we would also request that the no contact with Jordan Atkins in this case be lifted.
So,
You know, we've addressed this a couple of different times and each time we've moved a little bit more towards contact. I would defer to the court. The court's aware of all the facts that we have because they're in the police report. She does want to have contact. She did make that request in front of the Traverse City judge that was handling the district court portion.
so Mr. Jaskowski, I'll ask that you prepare an order amending bond.
Yes, Your Honor.
Case to allow that. So Mr. Rotan, the court will agree to remove that restriction. However, all of your other bond conditions remain in effect. It's important that you provide all those other conditions.
Absolutely. Thank you.
Thank you. William Lamont, case number 194499 and 25099.
Sierra Coke on behalf of the people.
Dylan Jaskowski on behalf of Mr. Lamont.
Do you have any objection to Mr. Jaskowski representing?
Not at all.
Mr. Lamont, you had a chance to review. Jaskowski, are there any corrections that you can do?
No, Your Honor, I don't believe so.
And Ms. Coe, do people have corrections?
No, Your Honor.
Anything on behalf of the people who are
And Mr. Lamont has some mental health issues. We've talked about them lots of times in the court. I hope that he continues to address them. If they don't, we'll continue to see him. You know, if he doesn't, then, or if he does, then hopefully we don't see him again and he's learned from this. No, and I would ask the court to follow the recommendation. I think it's appropriate.
Mr. Jaskowski?
Your Honor, I would concur with what Ms. Koch said. I believe the recommendation is appropriate. I know Mr. Lamont is working on his mental health, and I would just ask that he be able to continue to do that as well.
Mr. Lamont, anything that you wanted to say?
I'd just like to say I'm glad that you're feeling better.
Thanks. I'm familiar with the circumstances here. Obviously, we had a hearing and took testimony. And although the court found that you did violate your probation, I think given the circumstances that I don't think there's a need for any additional sanctions. I think it's been addressed by the jail credit that we have. So I think the recommendation is over there. The court is going to follow the recommendations. That's the file number 194499, 128 days. Crawford County Jail credit for 128 days served. File number 225099, 7 days. Crawford County Jail credit for 7 days served. The court is going to discharge you from your probation as to both files. I think that at this point we've done all that we could do through the probation. The court is going to discharge you. That's the second run current. The court will preserve any outstanding fines or costs. You do have the ability to appeal this sentence. Mr. Jaskowski, acknowledgement of appellate rights for Mr. Lamont. Mr. Lamont, these are your appellate rights. We just need you to
You can sign right there.
And then, Your Honor, I did want to just get on the record with regarding this. I know it wasn't part of any sort of deal, but I know there's an upcoming trial date against Mr. Lamont as well. It was my understanding, talking to Mr. Truce, that would be coming off the docket.
It's been resolved.
Okay.
Yeah, it's
Thank you. With Ms. Melon, I do hope that you continue to follow through. Please stand. Please do that. Otherwise.
Good luck.
Thank you.
There should be two
Yeah,
copies,
not here.
one for each case that he needs to sign.
Hey, Will.
Sorry.
Otherwise, that concludes our morning docket. Or it'll be recessed. So